Edited copy.
Today in the Fulchester Crown Court, Kenneth John Povey and Margaret Ellen Povey stand indicted that they jointly on the 22nd of November 1973 in the city of Fulchester murdered Charles Oldbury, and on the 7th of November, together with Leonard Saxton, with intent to defraud, conspired to forge a certain codicil purporting to be the codicil of Charles Oldbury. To both of these indictments they've pleaded not guilty. Mr. Marcus Golding, prosecuting for the Crown, will address the jury.
Members of the jury, on the afternoon of Wednesday, the 7th of November last, a solicitor's clerk, one Leonard Saxton, called by appointment on an old man at the residential hotel where he'd lived for the past 3 years. The appointment was at the old man's request and had to do with the signing of certain documents connected with shares. The solicitor's clerk afterwards took tea with the old gentleman and then left. Now, with him, he took not only the signed documents, but, and this is the gravamen of the case, the old gentleman's signature to a codicil of his will. Now, you might not at first suppose this to be at all out of the ordinary. Leonard Saxton was employed by Dimmock, Osprey and Turberville, a much-respected firm of solicitors, which had handled the old gentleman's affairs over many years. However, I must tell you that notwithstanding this position of trust enjoyed by the solicitor's clerk, the codicil had been drawn up without the old gentleman's knowledge and his signature to it obtained by a trick. To state it plainly, the old gentleman was a rich man. Indeed, all residents of this particular rest home were well provided for, Charles Oldbury particularly so, and the effect of the codicil was calculated to divert a substantial portion of his estate from the true beneficiary to the accused persons, Mr. and Mrs. Povey. Those, members of the jury, are the facts giving rise to the matter of the lesser charge. I come now to the events of a fortnight later. The evening of Thursday, the 22nd of November, was especially cold. Dinner at the hotel is served early, no doubt out of concern for digestions past their prime, and at about 8 o'clock that night, Charles Oldbury went upstairs to have a hot bath before retiring. From the moment he left the dining room, he was not seen alive again by any save those two persons now accused of his murder. His dead body was removed from the bath later that night, and a post-mortem examination subsequently carried out. Now, the clinical indications were not the anticipated ones. Indeed, as you will hear, the findings lead to the conclusion that this was an unnatural death.
What counsel is saying is that the deceased's death was considered to be not from natural causes. The use of the word unnatural in this context carries no bizarre implications.
I'm obliged to, my lord. That's all I wish to say by way of introduction to this case. I now call Mr. John Osprey.
John Osprey, please.
You are John Osprey, a practicing solicitor?
Yes, my offices are in Bank Building City Centre.
In November of last year, did you have in your employ a clerk, Leonard Saxton?
I did.
He'd been employed by you for some time?
12 years.
Mm-hmm. And during that time, had you any cause for complaint?
None. He was completely reliable.
You had ample opportunity to form judgment as to his character?
Oh, yes, indeed.
The fact that you were content to employ him in this position of trust for such a time speaks for itself.
A most scrupulous man.
A most scrupulous man, thank you. Now then, Mr. Osprey, were you at your office in the early part of November of last year?
No, I was away. I was away on a fortnight's holiday.
And during the 2 weeks you were away, who was in charge of the office?
For routine work, Mr. Saxton.
And what if a matter had arisen requiring fully qualified professional opinion?
My partner, Mr. Dimmock, was available.
Mr. Osprey, when did you hear of Mr. Oldbury's death?
The very next morning, on Friday the 23rd.
And did you on that day visit the Pines Hotel?
Yes, during the afternoon. I went through his effects there.
And what did you find among them?
Well, there were various papers of a business and private nature.
Business?
Share dealings, some property investments, that sort of thing.
And the private papers?
Birth certificate, marriage certificate, some old letters.
He was a widower, Mr. Osprey.
Yes, my lord. His wife died some years ago.
Anything else?
A recent codicil to his will.
Had you seen it before?
No.
From which we may infer that you hadn't drawn it up.
No, my lord.
And do you now produce the codicil? Exhibit 1, please. My lord, there are copies for the jury. It's dated November the 7th, 1973.
Yes, this is it.
Were you surprised to see it?
Oh, extremely.
Thank you. Now, I think it would be helpful if you were to tell the court about the deceased. He was, I believe, a retired shopkeeper.
Yes, actually, he owned several home decorating shops. He sold out to one of the big companies when he retired.
Yes, he was a man of considerable substance.
Oh, yes, indeed.
Now, you've told his lordship that Mrs. Olbury died some years ago. What immediate family had he?
2 daughters, both married, and a nephew.
My lord, I would like at this stage to introduce Charles Olbury's will. It is, in fact, an agreed exhibit, but perhaps we should call it Exhibit 2.
Yes. I've no objection, my lord.
Now, that is the original of the will drawn up by you to the instructions of the deceased and witnessed by you?
It is.
That is your signature?
Yes, it is.
Yes. It contains 3 principal bequests, does it not?
That is so.
Will you please tell the court who the 3 named principal beneficiaries are?
Well, his 2 daughters and his nephew.
And the amounts?
£30,000 to each.
Yes, thank you. So Mr. Olbury had not indicated to you that he wanted to change his will?
Oh, certainly not. I had no idea.
Thank you.
Mr. Osprey, what did you do when you returned to your office at Bagn Chambers?
I sent for my clerk, Mr. Saxton.
Why did you do that?
Well, his signature appeared as a witness to the codicil, together with that of a Miss Maria Novati. I was dumbfounded that Mr. Olbury had not told me what was in his mind.
Were you satisfied with what Mr. Saxton had to tell you?
Well, he wasn't really able to throw very much light on it.
And there the matter rested for some days?
Yes, until a few days later when I received a telephone call at home from Mr. Saxton.
And as a result of that telephone call, did you advise him to do something?
Yes, I told him to go and see the police the first thing in the morning.
Mr. Osprey, you've had dealings with the deceased over several years. Now, plainly, you were able to form judgments about his business sense.
Yes.
Was he methodical in his methods?
Oh, extremely.
Punctilious, too strong a word?
Oh, indeed not. Everything was most carefully considered.
Now, forgive me for laboring the point, but with regard to documents, how was he?
Oh, he read everything. Read everything.
Thank you, Mr. Osprey.
Thank you,
Lord.
Mr. Osprey. I don't think we need question you further.
I call Leonard Saxton.
Leonard Saxton, please.
Leonard Saxton, did you receive a telephone call from someone on Monday, the 5th of November?
Yes, from Povey.
Kenneth Povey, the defendant. What did he say?
Mr. Povey asked me to draw up a codicil to Charles Olbury's will and take it along with some other papers for signature.
And did you do that?
Yes, 2 days later, Wednesday the 7th, I called at the Pines with it and some other papers.
Will you please tell the court what then took place?
I saw Mr. Olbury and obtained his signature to the papers I had brought.
Including the codicil?
Yes?
Did he make any comment on it at all?
No, sir.
Maybe he be shown Exhibit 1, please. And would you look at that and say whether it is the document as drawn up by you?
Yes, it is.
Its effect is to remove Mr. Olbury's nephew from among the legatees and give his share to Mrs. Povey, is it not? Hardly an everyday occurrence to disinherit a member of one's family, and yet you say that he made no comment on it.
That's right, sir. He made no comment because he didn't see it. I slipped it in with the other papers and made sure that though he signed it, he did not see it.
And why did you do that?
It was what I'd been told to do.
Who told you?
Kenneth Povey.
Well, I'll return to that in a moment. Now, what happened after Mr. Olbury signed the various documents you brought?
I had tea with him. He asked me to.
And what was his demeanour at tea?
Sorry?
Was he worried or depressed?
No, not at all. He seemed very happy.
And when did you next see either of the accused?
As I was leaving. Povey asked me if I'd got it.
And what did you understand him to mean by that?
The codicil being signed.
Yes, well, let's now go back to a few months ago. What was your financial situation last summer?
I was in debt. I'd been backing horses.
And how did you get out of debt to the bookmakers?
Mr. Povey loaned me £500.
Did you borrow it from him, or did he loan it? You take the distinction.
You are being asked which of you took the initiative.
He volunteered the money, my lord.
How much?
£500.
Was there a term to this loan?
It was lent on the basis I would repay it when I could.
And have you repaid it?
No.
Then it is still outstanding.
No.
Will you please explain that?
It was made clear that the debt would be written off if I did what I was asked.
And what did you take that to mean?
Drawing up the codicil and getting Mr. Olbury's signature on it.
And was that promise quite explicit, or was this merely your assumption?
Kenneth Povey said, get his signature to that and we'll forget about the money.
When did he say this?
Over the telephone, my lord, on the Monday, the 5th of November.
Yes, I see. It might be appropriate, Mr. Golding, if you took this opportunity to clarify for the jury this witness's situation.
I'm obliged to, my lord. This witness, Leonard Saxton, has, of course, been charged with having taken part in the forgery of this codicil, also to having obtained the signature of Miss Maria Novati, a servant resident at the Pines Hotel, having told her that Mr. Olbury wished to leave her a small token in his will and that her signature was necessary to the document. Miss Novati was told not to mention this to Mr. Olbury, as he did not wish to discuss his will with anybody, and Mr. Saxton has since pleaded guilty to that charge and has indeed been sentenced to 5 years' imprisonment for it. The result is there is no reason to suppose that any testimony of his might be self-incriminatory, inasmuch as his responsibility in these events has already been determined. My lord, I would like to introduce some further documents, Exhibits 3 and 4, a statement of account for Kenneth Povey's bank, and a paying-in slip on Leonard Saxton's bank.
Agreed, my lord.
Yes.
So, you were to obtain Mr. Olbury's signature to this fraudulent codicil, and in return, the loan would be forgotten about. Mm-hmm. Was that consideration the sole inducement, Mr. Saxton?
I was told I should not go empty-handed when Mr. Olbury died.
Kenneth Povey said that?
Yes.
Mm-hmm. Now, I want you to be very clear about what I'm going to ask you. Was anything ever said by either of the accused about when Mr. Olbury might die?
Not at that time.
You're certain of that?
Yes, I clearly recall when it was first hinted at.
Hinted at?
The meaning was very clear. The morning after Mr. Olbury's death, Kenneth Povey phoned me at the office. He told me to meet him at 1 o'clock in the Castle Public Bar.
That was Friday, the 23rd of November?
Yes. I met him in the bar, and he bought me a drink. He said, Leonard, our problems are over. I asked what he meant, and he said, the old fellow's dead. I asked how he died, and Povey said, all that concerns you is that he is dead. I wasn't there long. Just as I was leaving, Povey said, Len, this codicil business, it's between you and me, isn't it? I said, of course. And he said, good. Only if it ever got out, you'd be in the dock with me, and it wouldn't just be the forgery, would it?
And those were the exact words?
Yes.
Thank you.
I suggest, Mr. Saxton, that your entire testimony is unfounded, that you are motivated by malice, in short, that you are lying. So you insist that the £500 Kenneth Povey gave to you was a loan? You say he offered you this large sum of money without even being asked?
He did?
Well, that's a bit odd, isn't it? I mean, as my learned friend suggested, the Poveys had recently fallen onto hard times. How is it that he suddenly was able to find £500 and thrust it on you? Obviously, you find it remarkable as well.
No, Miss Tate, the witness hasn't said that.
Oh, I withdraw that imputation, my lord. Do you not find it strange that Mr. Povey was suddenly able to lay his hands on £500?
I didn't know the state of his finances.
Ah, now, is that quite true, Mr. Saxton? Isn't it a fact that in April of last year, Povey discussed with you the taking out of a second mortgage on the Pines?
Well, he may have. I don't recall clearly such a conversation.
Come now, Mr. Saxton, did you not recommend the services of a Mr. Pocock, mortgage broker, also of bank buildings?
Mr. Saxton?
I may have, my lord.
You did, and you know it, Mr. Saxton. My client took up your recommendation and went to see Mr. Pocock. Now, that is right, isn't it?
You do not recall this, Mr. Saxton?
It had slipped my memory, my lord, I do now.
So, in April of last year, you were aware of Mr. Povey's need for more funds?
Yes, I suppose so.
And yet, in August of last year, he lent you £500 as if there was not a cloud in the financial sky. But you knew, and we know, that that is far from being the case.
What is the relevance of this line, Miss Tate?
My lord, I am seeking to show that a man who needs to get more money by getting a second mortgage is unlikely to be as free with it as the witness suggests.
Yes.
The fact is, Mr. Saxton, that you have conveniently forgotten Mr. Povey's financial state, because otherwise it would cast a doubt on your claim that he freely offered the money to you. He did not offer this money to you, Mr. Saxton. You demanded it.
You understand, Mr. Saxton?
Yes, my lord. It is as I have testified.
What is your salary, Mr. Saxton?
Must I answer that, my lord?
Oh, I see no good reason why you shouldn't.
£2,500 a year.
Will you please describe again precisely how you say you duped Mr. Oldbury?
I put it between two share certificate receipts which he had to sign. I just indicated where he should put his name.
But we have heard your employer say that Mr. Oldbury was a most punctilious man about such matters.
Oh, my lord, Mr. Osprey did not actually say that. He merely assented to my learned friend saying.
Yes, Mr. Golding, I think that's right, but it doesn't negate the point that counsel is making. The important thing is that the witness did assent to the proposition.
Let me put it even more directly, then. Mr. Osprey told us that Mr. Oldbury was very careful about business papers. But in spite of this care over documents, you would have us believe that you were able to trick him in this childish manner.
It is what happened.
I suggest that no such thing took place. I suggest that it was not Kenneth Povey who telephoned you on Monday the 5th of November, but Charles Oldbury himself.
It was Povey.
He instructed you regarding the codicil on the telephone and made an appointment to see you 2 days hence. At that time, you took the prepared codicil and the other documents that he requested, and there you got his signature in a perfectly ordinary, straightforward manner. You then took tea with him and you discussed the weather.
That is not true. Except about tea and the weather.
Is it true, Mr. Saxton, that your entire testimony is invention and actuated by malice? Well, let us come to the day after Mr. Oldbury died. That is Friday the 23rd of November. Now, you're saying that Kenneth Povey telephoned you and arranged to meet him. What were his exact words?
He said, "Something's happened. Meet me in the public at the castle, 1 o'clock. I'll tell you about it."
Did you not immediately question him about it? I mean, something's happened.
I took it to mean about the codicil.
Just answer the question, please.
No, I didn't ask him anything.
So you weren't curious? Could that be because you had telephoned him?
He called me.
Very well, we'll come back to that. But let's consider the actual meeting. Now, according to you, Povey said, "It's between you and me. If ever it gets out, you'd be in the dock with us," right?
That's part of what he said.
But you did nothing about it.
I thought about it, but I didn't do anything.
No, indeed. You didn't contact the police for several days. Although, as you say, you had this positively sinister conversation with Mr. Povey. What did you say to Mr. Osprey?
I simply said Mr. Oldbury wanted to see him, and hearing Mr. Osprey was on holiday, he'd asked me to go along instead.
That's all you said?
At first, yes.
So you spoke about it later?
Yes. I couldn't stand it. A few days later, it sort of came to a head, and I rang Mr. Osprey at his home. I told him the truth, that I'd obtained Mr. Oldbury's signature to a fraudulent document for personal gain, that I'd done so under instructions from Kenneth Povey, and that it was my belief Oldbury had been murdered.
Murdered? But your reason for coming forward was not fear of being implicated in a murder charge. It was pure vindictive spite.
That is a lie.
This is all I have for this witness.
You wish to re-examine Mr. Golding?
Thank you, my lord. Mr. Saxton, you have experience of the law. No doubt you see the drift of my learned friend's question.
Yes, sir.
Perhaps you would assist the court by telling us what motives you have had for coming forward and testifying against the accused.
None except what I've said.
My learned friend has suggested malice. Had you any dealings of a business or personal nature with Povey prior to the events of November the 7th?
None, sir. Apart from the loan back in the summer.
Yes, you're at a loss then to know what she could be getting at.
Completely. Absolutely.
Thank you. My lord?
Yes, Mr. Saxton, one thing. Counsel asked you if you'd had any dealings with the accused, Kenneth Povey, and you said that you had not. Does that denial apply equally to Mrs. Povey?
Yes, my lord.
I am obliged to you, my lord.
You may leave the witness box, Mr. Saxton.
Dr. Leslie Fulmer, please.
Dr. Leslie Fulmer, please.
You were called out late on the evening of the 22nd of November to the Pines Residential Hotel.
Yes.
Yes. The caller, who identified herself as Mrs. Povey, said, "One of our old men has had an accident. He's in the bath. We can't bring him round." Now, is that correct?
Yes.
And when you got there, what did you find?
The patient was on the bathroom floor. He was lying on his back, wrapped in a large towel.
Did you notice anything about this towel?
It was hot, as if it had just been taken off a radiator.
Yes. What did you do?
I checked for a heartbeat, but could detect none. Neither was there any pulse. There was no trace of breathing. The body was cold, and the pupils widely dilated. I ventilated the lungs by mouth-to-mouth respiration and applied external cardiac massage, but without effect. After half an hour, I was satisfied that he was dead.
Yes. Now, did you conclude anything from what I believe is termed auscultation?
Oh, bear with us, Mr. Golding.
Well, it's a medical term, my lord, meaning to judge by listening the condition of heart and lungs.
Well, wouldn't it have been simpler if you'd asked that in the first place?
Well, doctor?
I thought it strange that his lungs seemed not to be full of water.
Yes. Now, was there anything else you noticed?
Well, the coldness of his body I've already mentioned, but it was extreme, and I was surprised.
But you tell us he was wrapped in a hot towel.
Even so.
It didn't seem to have warmed him palpably.
No, my lord.
Now, what general view did you form in the light of his age and the circumstances in which he was found?
I thought it most likely that he had died of heart failure.
And did you so certify?
Well, I didn't sign a death certificate. As I hadn't attended the deceased before, I felt unable to issue one in the circumstances.
Do you mean that you entertained suspicions?
Oh, no, I don't mean that. Merely that I felt a degree of doubt over the clinical facts of his death.
Thank you.
Apologies, my lord. Was the deceased's head wet?
His hair had been. It wasn't sopping wet when I saw him, but it clearly had been.
Was the bathroom wet?
No.
Not splashed, as you might expect from lifting an inert body from the bath?
I don't recall that it was.
Yes. Was the bath full of water?
No, it had been run away.
It had been run away. I see. Now, was it a cold night?
Extremely. I'd had to use defrost on my windscreen.
And therefore below freezing? Yes. How long did it take you to get to the Pines?
10 minutes.
And you left how long after the phone call from Mrs. Povey?
I left straight away.
So at the most you cannot have been more than a quarter of an hour?
That's right.
Yes, good. Now, what was the state of the bathroom window? Was it steamed up or not?
No, I don't recall any condensation.
You would recall such a detail?
Yes, I thought the bathroom was dreadfully cold, and I was concerned for the patient. I looked to see if the window was properly closed. It was shut, and I remember that the glass was quite dry and clear.
Did either of the accused say anything?
Well, only Mr. Povey was in the bathroom.
And did he say anything?
He mentioned something about Mr. Olbury having eaten a large dinner. I assumed that he had the possibility of cramp in mind.
Yes. Dr. Fulmer, what would you expect to be the reaction of someone swimming, say, who'd been attacked by cramp?
To shout for help.
To shout for help. Thank you, Dr. Fulmer.
Yes, Miss Tate.
Dr. Fulmer, how long have you been qualified?
6 years.
And how many cases of drowning have you attended?
Well, not many, a few.
10? 12?
3 or 4.
3 or 4? Well, that's not a great many on which to build a body of experience.
What is your point, Miss Tate?
I'm coming to it, my lord. Are you more familiar with hypothermia?
Miss Tate, in these matters we are but laymen.
Subnormal body temperature, my lord.
Thank you.
Yes, I am considerably more familiar with it.
I'm sure you are, Dr. Fulmer. Did not the British Medical Journal publish an estimate of 50,000 annual deaths from it?
Yes, it's more common than we would like to suppose.
Amongst old people living on their own?
Yes, my lord, they're the ones principally at risk. Like malnutrition, they don't realize what is wrong until it's too late.
Now, what treatment would you normally use in such a case?
Well, if possible, I would warm the patient.
How?
A hot bath would be best.
Now, why did you not use this method in this case?
I didn't consider that hypothermia was indicated.
Really? But you've told us that the body was abnormally cold to the touch. Now, isn't that a classic sign?
Doctor?
Yes, it is a sign.
And moreover, the bathroom was extremely cold, you said?
Yes, but I considered drowning following a heart attack as the most likely condition, and time was critical.
Delay would be fatal.
Yes, heartbeat and breathing must be very quickly restored.
Did you not say in answer to my learned friend's question that there seemed to be no water in the lungs?
Yes.
But you applied artificial respiration all the same.
I have explained why I did.
Please make your point, Miss Tate.
Well, my lord, I hardly like to. Isn't it the case, Dr. Fulmer, that in view of recent medical knowledge, ordinary resuscitation techniques can be fatal to a patient comatose from hypothermia?
Yes, I believe that is so.
Then perhaps it was you who killed Charles Oldbury.
My lord, I must object to such a slur answer to the doctor.
The case of the Queen against Povey and Povey will be resumed tomorrow in the Crown Court.